One of the interesting and important case coming before Allahabad High Court in the case of Patanjali Ayurved Limited. Two important questions are being answered and held by the Honorable Allahabad High Court. First, whether conclusion of proceedings under section 73 or 74 can be considered as a conclusion of proceedings for penalty under section 122 of CGST Act. This is the first question. Second question, for determining any penalty for offences, 21 offences under section 122, whether any proceedings need to be concluded under section 132, which is prosecution proceedings. Whether adjudication officer, proper officer can adjudicate, pass the penalty order, or it has to go through a criminal proceedings under section 132 to section 138 of CGST Act. Important one. Before I say what is being held by Honorable Allahabad High Court, let's listen this part. Let me first give a glance of certain provision. If you go to section 75 subsection 13, it is clearly saying if penalty is being levied under section 73 or 74, then no penalty can be levied under any other provision of the GST law. So if you are being levied penalty, आपके ऊपर 73, 74 में penalty लग गई, तो किसी और provision में penalty आपके ऊपर नहीं लगेगी. पहली बात. Second, there's explanation. 1 Roman 1 after section 73 and 74, these two explanations are very important. First, Roman 1, notice or proceedings which is being initiated under section 73 or 74 does not include any proceedings under section 132 prosecution. So these are two separate proceedings, meaning thereby department can initiate both simultaneously. It's alarming position. Just take a note of it. Second, explanation 1 Roman 2, very clearly saying that any notice for the same proceedings to a main noticee for demanding the tax amount, if gets concluded, then it shall be deemed concluded for any penalty proceedings under section 122, 125, 129 and 130. This 129 and 130 got omitted from 1st January 2022. So meaning thereby, if proceedings against the main noticee gets concluded under section 73 or 74, it means for the same proceedings under section 122 and 125 penalty shall be deemed concluded for all other person. So for co-noticee, if there is any penalty, that shall be deemed as concluded. This is what explanation 1 Roman 2. Interesting, but you must listen this video carefully. Now what happened in this case? Patanjali Ayurved Limited, having 3 manufacturing units in Uttaranchal, Haryana and Maharashtra, there was DGGI investigation pertaining to wrongful availment of credit and circular trading. So-called notice was issued to the main noticee, Patanjali Ayurved Limited, Uttaranchal, and there was a demand of IGST liability 9.03 crore. Alongside, there was penalty for certain offences for circular trading under section 122 subsection 1 Roman 2, issuance of invoice without supply of goods or services. Roman 7, when you are availing credit on such invoice or utilizing the credit. So there was demand under section 74 to the tune of 9.03 crore, but the penalty which was demanded for different and separate offence. As I said, 122 subsection 1 Roman 2 and Roman 7, important one, circular trading, issuance of invoice without supply of goods, and correspondingly wrongly availed credit or utilized credit. What happened? The demand proceedings under section 74 got dropped. it was dropped by the adjudicating authority. So once it is being dropped, petitioner has filed a writ petition for all the penalty which was alleged to be levied under section 122 subsection 1 Roman 2 and Roman 7 for circular trading and wrongly availed credit or utilized credit. What they argued before the court, if my demand which is getting concluded under section 74, then quite obvious my all other proceedings gets dropped. They have relied explanation 1 Roman 2. And second point which they have argued, that the penalty which is supposed to be levied under section 122 can't be levied unless a prosecution proceedings gets concluded under section 132, and it is only after criminal proceedings. So adjudicating authority is not a proper officer for confirming penalty or alleging penalty. So these were the two important issues in this particular case. What is being held? First point, conclusion of proceedings under section 74 ipso facto does not await proceedings for penalty under section 122. And quite obvious in this case, there was a particular demand of 9.03 crore which is on account of non-payment of tax, but penalty was for certain specified other offences, circular trading, 122 subsection 1 Roman 2, 122 subsection 1 Roman 7 wrongly availed credit or utilized credit. So penalty was alleged for different and separate offences, which is separate with respect to the demand alleged under section 74. So in a given case, what Honorable Allahabad High Court has said, that just because 74 demand proceedings gets dropped, which was for the non-payment of tax, does not mean that your proceedings under section 122 for penalty gets vacated. So 122 subsection 1 penalty which is being alleged in a so-called notice, it is for separate offences, and for that penalty proceedings may continue, and that can be decided by proper officer, adjudicating officer, and it need not require to go through criminal proceedings as pleaded by the petitioner under section 132 to 138. So penalty under section 122 is independent, and that can be levied if it is for separate offense. Now, one or two important aspects, let me tell you as a final outcome. First, if it is for same offense, let's assume 73, 74 proceedings got started, and for that only 122 penalty is also being alleged, then there should not be double jeopardy, no double taxation, no double penalty. And that is what we are getting a clarity when we are reading section 75 subsection 13, that penalty under section 73, 74, if it is confirmed, then penalty under any other section cannot be levied. Section 75 subsection 13. But difference in this case was penalty under section 74 was for non-payment of tax, but the penalty for section 122 subsection 1 Roman 2 and Roman 7, it is for circular trading and wrongly availed credit, separate offences. Hence, this judgment is coming out that even though demand gets dropped under section 74, is not giving you relief for penalty proceedings under section 122, the first one, we need to understand, and that is what we need to be careful about. Second part, any notice under section 73, 74 does not include proceedings under section 132, prosecution. So these are two separate proceedings and can continue simultaneously. So alarming one. Third one, आपके सारे provision अच्छी तरह समझने हैं. Third one, explanation 1 Roman 2. For same proceedings to a main noticee under section 73 or 74 gets concluded, then any penalty for all other person for the same proceedings shall be deemed to be concluded. Meaning thereby, अगर main noticee ने 74 का tax, interest, penalty pay कर दिया which may be 15% before show cause notice, 25% within 30 days of show cause notice, 50% within 30 days of order, otherwise 100% of tax amount. अगर मेन नोटिस ने टैक्स इंटरेस्ट पेनाल्टी पे कर दिया फॉर ए पर्टिकुलर प्रोसीडिंग्स, उसी प्रोसीडिंग्स के ऊपर आप अदर को नोटिस के ऊपर पेनाल्टी नहीं लगा सकते. दैट इज व्हाट एक्सप्लेनेशन 1 रोमन 2, दैट इज व्हाट इट इज, शैल बी डीम्ड कंक्लूडेड. यानी डबल ज्योपार्डी नहीं होनी चाहिए. पर इलाहाबाद हाई कोर्ट के इस जजमेंट में दे हैव क्रिएटेड डिस्टिंक्शन. उन्होंने कहा जो 74 में डिमांड ड्रॉप हुई, दैट इज फॉर नॉन पेमेंट ऑफ टैक्स. बट जो पेनाल्टी हम आपसे मांग रहे हैं 122 सबसेक्शन 1 रोमन 2 एंड रोमन 7, विच इज सेपरेट ऑफेंस, circular trading, invoice without supply of goods, wrongly availed credit or utilized credit. So that is separate. So you will not get the relief when you look at explanation 1 Roman 2, which is given after section 74. Similar provision exists when you look at section 74 capital A, which is now common timeline for fraud and non-fraud cases. And same explanation that this provision 74 capital A is now applicable from financial year 24-25 onwards. So this judgment is giving a different perspective, but we need to understand the context and then we can decide what is coming out from this judgment. Worth reading. That is the reason I took longer time period for explaining this judgment. Hope you have got the digest. Your any suggestion, comment, must write back in a comment box. We all should try to understand in an easiest possible manner. Thanks for watching. Stay tuned. Thank you very much.